This case is a textbook example of how probation can unravel not because of one mistake, but because of repeated choices.
Today's courtroom centers on Anthony Mendoza, a defendant who had opportunity after opportunity, and a judge who finally reached the end of the line.
Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections to that report?
No, Your Honor.
Not from the state judge.
All right, Mr. Parker, you may proceed.
Well, a couple things I want to address. It's a situation I see quite a bit where he's ordered to have to scram and interlock. It's costing him $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GED program. All those things require money, and that's one of the big issues. But the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative, and this also in turn is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device, and in this incident he was frustrated and he wanted to take his boot off to show the director the problem that he had, and that's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants the opportunity to go back to he wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say of what happened with that, but I'm sure there's an explanation, and I think you'd also like to address the court, Judge.
Well, let me first make sure I've got the timeline, because it appears that I see that safety he completed and then was placed on zero tolerance in the high-medium caseload. And after that, there was an issue where he was testing positive, again, for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safe P.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safe P, and he